More and more young people considering getting married, but not so willing to do it because of the consequences of California law. And a lot of them consider doing prenuptial agreements, and there's so much uncertainty whether the agreement is going to be enforceable. This video is going to break down every single aspect in the prenuptial agreement, how to create a valid prenuptial agreement. First of all, the agreement itself, even if it's drafted really, really well, is not enough. Surrounding circumstances are equally important as the content of the agreement, which brings me to the first point. Should you download an agreement from online service or hire an attorney? Well, in California, you got to have drafting and reviewing attorney if you really, really consider having a serious enforceable agreement, because in the code section 1615 Family Code, it states that agreement as a matter of law is not valid if the person who is trying to enforce, which is going to be usually the other side, has not had an independent counsel, didn't waive an independent counsel in a separate writing, and did not get a separate memorandum of understanding what the agreement is about. So basically, if the other side says, I don't want to have a lawyer, I'm signing off, I'm waiving my independent counsel right, then still the person who drafted it needs to send the reviewing side a memorandum of understanding about the agreement. Let's pause for a second. First of all, that means the lawyer who is drafting it, because I don't think a lay person who is drafting an agreement would be able to create that type of memorandum, has to include almost everything. The case law, the consequences, and the likelihood of making a mistake in that memorandum is super high. So my first thing when someone calls me and says, I would like to have a prenuptial agreement in a week and, can you draft and review? No. One attorney cannot draft and review an agreement. Ironically, that's possible for estate planning. An attorney can draft for both parties an estate planning agreement, but not a prenuptial agreement, because in a prenuptial agreement, each party is against the other. They're inherently conflicting. One party is trying to protect, usually, and the other is waiving. That's the nature of the prenuptial agreement, because if you don't try to do that, then you don't need a prenuptial agreement, you just rely on California law. So each would need to have an independent counsel, which becomes now a situation where an attorney would tell you what I'm going to tell you. You have to have financial disclosures, meaning you have to disclose assets and debts currently owned or owed, and it doesn't matter where they're located. It's everywhere. It has to be absolutely full financial disclosure on both sides. Income, assets, valuations. If you don't have a home appraised value, estimate at the best of your ability. If you have a business, estimate at the best of your ability. If you are on the drafting side, I would even a little bit overestimate, because if you underestimate, then the other side could say, listen, actually, at the time of a divorce, if I knew that this business was 5 million versus 1 million, I would not have signed this agreement. So you didn't disclose the value, because now I hired a business evaluation expert and it turns out your business was worth, at the time when we signed the agreement, 5 million, and therefore I'm setting it aside. So the most common reason to set aside is no lawyers on the side who is enforcing it, no full financial disclosures, and this is the vague one, didn't sign voluntarily. And then, of course, we have 7-day rule. So let me talk about the easy one, 7-day rule. 7-day rule means that the agreement before signing, and remember, we're signing a prenuptial agreement before getting married. So before signing the agreement, we have to have an agreement to stay untouched on substantial changes. What is a substantial change? Not a typo in a name, not some comma, basically no grammar mistakes. Substantial changes, oops, I didn't disclose my business in Argentina that was $1 million. Or actually, I'm gonna cut spousal support by X amount of years and X amount of dollars. That is substantial change. The agreement needs to be untouched for 7 days. Otherwise, as a matter of law, it's not valid. Then the party who drafts it, I suggest to start drafting it a few months in advance, depending on the complexity of your agreement. Of course, if you have very little to write and very little to disclose, timeline can be shorter, but ideally start with at least 3 months. Draft it, present it as soon as possible to the other side so they have not just 1 week, 2 weeks, 3 weeks. They have to have time to find an independent counsel. So the definition of independent counsel is they choose their counsel independently. So if you are the drafting side and you call your other future spouse and say, hey, contact Ben, he's my buddy, that's not going to be an independent counsel. I usually provide at least 3 names of lawyers to choose from if I'm being asked to provide. Of course, if I'm not being asked, they need to pick their own independent counsel. It has to be counsel that understands their language. It has to be a counsel who is practicing family law. It's not written as a matter of law, but it's common sense that at the end, you want to avoid any reason for them, for the other side trying to set it aside. So they need to understand. The counsel need to be able to explain, therefore, community property law, family law. Attorney independent, meaning you're not influencing their decision to pick an independent counsel. And of course, money. Usually you create a prenuptial agreement to protect your rights, and if the other side does not have the money to pay for the counsel, you better pay them to pay the lawyer. Because if you pay the lawyer directly, and the lawyer doesn't send you a third-party fee waiver, which means just because you pay, you don't get to influence my case, says the lawyer on the other side, then it could be potentially some implication that you influence the lawyer. So pay your future spouse to pay the lawyer whatever it takes to review the agreement, because it's protecting you. And you don't want them to say, actually, although I had an independent counsel, although my counsel did explain to me, but my counsel told me we cannot negotiate because the retainer paid is only for reviewing and not negotiating, so I didn't have the money to pay. And that becomes signing the agreement involuntarily, meaning I didn't have a choice, basically. Or if you have a lot of assets and it's close to the wedding and everything is already set up and the other side feels compelled to sign because otherwise everything will fall apart, that's another reason for an agreement to be involuntary. I had a situation where the other side disclosed a month in advance every single asset, but 10 days before the wedding sent an agreement and said, this is final. So opposing counsel sends me the agreement, says this is final, but it didn't have the disclosures. I know I saw the disclosures, but they were not included, and says, let's sign it in 7 days. I said no. First of all, the agreement is not final until it has everything to be final, to be signed as is. And opposing counsel, no, we had disclosures and this is final. So, and ironically, I went to every month I have a prenup group with family law specialists like I am, where we discuss all kinds of case laws and discuss about prenuptial agreements. And so the group had about 12 participants, and I asked them, all attorneys in the group, I said, please raise your hand if you think the agreement is final if it doesn't have financial disclosures attached, although it was previously disclosed fully, and everyone said that's not final. So I called up opposing counsel. I said, look, I want this agreement to be valid. My client wants it to be valid, although she's the out spouse, although she would benefit if it's not valid, but it's going to be your malpractice too. I know it's not final. I asked the group, it's not final. Can you prepare the disclosures and make it final within 24 hours? And unfortunately, if you have done it before, they wouldn't have to sign the agreement on the day of the wedding. So basically, because opposing counsel didn't have a sense of what it takes to have a final agreement, it became this rushed situation where they literally had to order a notary coming to the home on the day of the wedding before they left. So this video will help you to prevent these type of little nuanced situations that unnecessarily make your life difficult. Now, I also had an agreement that I drafted, and 3 years later, the client comes back and calls me on the weekend crying, saying, my wife it's not working well, so we're divorcing. And the next thing you know, he hires me and she files a motion to set aside the prenuptial agreement. I know that this agreement is valid. I drafted it, I negotiated it, I followed every single rule that I just told you about to make this agreement valid. And it was around pandemic, and she filed this motion. She filed a FL 300 request for order, and she says, set aside agreement, it's unconscionable. It was signed under duress. And so she said those couple sentences, and unconscionable would be if my client suddenly, at the time of the enforcement of the agreement, became absolute multimillionaire. I think at that time he was making, when he signed the agreement, $300,000, and at the time of the enforcement, 3 years later, he made $1 million. So about $700,000 more. It did make the agreement unconscionable because it's not to the extent of, oh my God, right? So what happened is, in the prenuptial agreement, she got up to, I believe, $90,000 a year for spousal support based on half of the length of the marriage. So it would be, if it was, let's say, 2 years of marriage, in our case it's 3, so making it 1 year, she would get up to $90,000 or 10% of his income, whatever is higher. So he would owe her whatever money he would owe her under the prenup. How did I save this situation is I sent her discovery. I sent her request for admission, admit that the prenup is valid. One question. I said many questions, but the first question, admit that the prenup is valid. Because if she says no and we persevere, then not only do we get prevailing party attorney's fees according to the prenuptial agreement, but we also get according to the discovery rules, because she in the litigation already said no, it's not valid, and we have to go and prove it. So the court has 2 reasons to give us prevailing party attorney's fees. On the prenup, the court might say, well, maybe prevailing party attorney's fees is the fees are unreasonable or high, but under the other rule, there will be different rules. So we had 2 options to seek fees, and that's creating stress for her, because now she knows on 2 fronts she might have to pay his fees. And she's trying to get money, not to pay money. So I sent the list of requests for admissions. I sent special interrogatories, which means questions. Explain how you think the agreement is unconscionable. So basically, I'm narrowing down her answers. When she brings up something new in trial, I can cut it out because she didn't say it in the discovery. And so after I sent this discovery request, miracle happened. She realized, okay, well, actually, I just tried to set it aside so I can get more money. And we came to an agreement to just follow the agreement. Maybe we gave her $10,000 more or something like that. But basically, he walked away way better off than having to go through the trial defending his prenup. So what I'm saying is, a prenup is like life insurance. You gotta have it so that you have something to show, but it's not guaranteed that it's valid until the court says it's valid. So the case of appeal that came out in 2023 list states that the agreement is not valid until the court says so, which makes it even less incentivizing to have two adults create a contract. Because if it's inherently invalid, then why would we even get married? And I don't agree with the case of appeal. I don't agree that the prenup should be invalid as a matter of law, but it is what it is. And that's why I have this video, so that if you do decide to get married, if you do decide to have a prenuptial agreement, just do your best to follow the rules as of now. When you move to a different country, when you move to a different state, talk to an attorney who practices family law, ideally family law specialist. It's a term of art. It's a degree that's given by the state bar after passing certain tests, exams, and passing referrals by different attorneys, passing moral character. So it's the highest level of family law experience someone could have, and they have to have 40 hours of education every 3 years to show versus 20-something. So you're talking to someone who is better off to explain family law in their state. I had also a case recently where someone had a valid prenup in Europe, but in Europe, like France, Germany, they don't have financial disclosures. So they sign a prenup that everything is separate, no support, and then they come to California, and guess what? The prenup is not valid. So what does it tell you? That when you travel, it's not when you get divorced, it's not where you got married that matters, it's where you're residing right now. So after 6 months in California, when you file for divorce and you lived 3 months in the state of, let's say, San Francisco, California law applies, even if you had Europe valid prenup ready to go to enforce. No, it doesn't work like that, because we have public policies. We enforce what's in the best interest of protecting rights in California. So lesson learned, once you move, talk to an attorney, create a postnup, or if you know when you get married that you are going to move to California to live, then create, before getting married, a prenuptial agreement under California law, which includes everything I just described. So you can tell how many nuances prenuptial agreement is in terms of how much a prenuptial agreement costs to create and how long does it take. It depends, of course, on the level of expertise you hire, depends on the time of the year you hire, depends on the rate, but typically it takes 10 hours of attorney's time to draft it. So depending on the complexity of the prenup, it would be up to 5 hours to draft an agreement, and then a couple hours for negotiating, questions. Unfortunately, a couple hours to ensure that the disclosures are correct. You would be surprised how many people don't do it correctly. So the feedback needs to be given. Then the attorney drafting or responding provides usually a letter to the client explaining what this agreement is about, what are the risks, what is the case law. Basically, the whole thing is about 10 to 15 hours. The reviewing side is, of course, half as much, because minus the drafting time. But similar steps to explain, to draft a letter, to do the disclosures, to look at the disclosures, to explain the law, to draft the letter and provide the law. I think I covered everything that prenuptial agreements entail. If I missed something or you have any follow-up questions, ask them down in the comment section below, and I will see you in my next consultation. Bye!